Fred, I wanted to ask you about the debate between the EU and the US, which obviously exists, and the convergence that we seek. Does it also go together with a shift from a consumer welfare approach to a sort of ordo-liberal approach to antitrust?
I think there are three differences between the way I feel the debate is going in Europe and in the US. The first one is that in Europe, the debate is led by the competition authorities themselves, by DG COM, by the CMA, by the French. They are pushing for changes. They are the force who say we don't have sufficient other resources or means or legislation, and therefore we need new things. In the US, up to the appointment of Lina Khan at the FTC, it was mostly outside the academic world, which was pushing for a revision of what competition authorities were doing, which was seen as being ineffective, insufficient. So I think that this creates a first major difference in the debate. The second major difference is that there is no discussion in Europe about the goals of antitrust. This debate is not at all about changing the goals of antitrust. And the reason for that is obviously the fact that we were not in the same place as the US was from that point of view. Irrespective of what the EU Commission says, I mean, Mario Monti, as early as 2001, said, oh, you know, the only purpose of competition law is to protect consumer surplus, consumer welfare. The courts have never accepted that. Okay, so we are in a situation where there's a much wider perspective on what is the goal of competition law. And I just want to make two quotes. One of them is from the US House of Representatives report on digital markets, the staff report, which says, by adopting a narrow construction of consumer welfare as the sole goal of the antitrust laws, the Supreme Court has limited the analysis of competitive harm to focus primarily on price and output, rather than on the competitive process, which Herbert doesn't like, contravening legislative history and legislative intent. Now, let me take two quotes from Europe, one from Advocate General Cocotte, who is the most representative of the legal tradition. The court should not, this was in the post-Denmark case, the court should not allow itself to be influenced by so much by current thinking, which means the economic approach or ephemeral trends. That's how she describes the economic approach, but should have regard rather to the legal foundation on which the prohibition of dominant position rests in the EU. And the second quote is from Wouter Wils, who says, what is the legal foundation? It is clear from Protocol 27, the internal market and competition, that Article 102 is a system of, the objective of Article 102 is a system of undistorted competition as part of the internal market. What some economists have done is to neglect the process value of undistorted competition, including the right to compete on the merits and equality of opportunity between economic operators. When you put all those quotations together, we are already where the US House of Representatives would like us to be. Okay. So we have a much wider scope of vision of what competition is all about. So where is the debate in Europe? The debate is purely or practically uniquely on what is the most effective instrument to enforce competition law. Is it law enforcement? Is it regulation? Is it regulatory power given to the competition authority? Is it regulatory power given to sectoral regulators? So it's purely a question of what is more efficient, what allows for faster decisions. And the competition authorities are both trying to get new instruments and regulatory instruments that they could use, even though there is a certain amount of questioning on this. For example, the DMA, nobody knows at this point if it were accepted, who would enforce it? It's not written in marble that it would be DG Comp. It could be DG Connect, or it could be a triumvirate of DG competition. So the debate in Europe is quite different from that point of view. There is less heated discussion, more pragmatic discussion of how to effectively enforce competition law.